Did you or a loved one apply for a marriage or family green card? You need to know these things about the process, which includes new 2025 USCIS rules that could seriously affect your case. USCIS just issued a massive update with stricter rules, automatic denials, and new interview requirements. I'll break down each change, what it means for your application, and what to do about it. Let's get started. I'm U.S. Immigration Attorney Sharifa Tharpe at ST Law Office. I also provide regular updates as well as information that empowers immigrants through their immigration journey. And today, I'm covering the official USCIS policy update that's making major changes. These are published changes in the USCIS policy manual that affect marriage-based and family-based green card petitions, and this is the I-130s. So, if you're sponsoring a spouse, a child, a parent, or you're the immigrant that's being sponsored, you need to listen up. 1. USCIS interviews are now mandatory in more cases. USCIS now requires interviews in more situations, especially if there are concerns about fraud or age-related red flags. So here are some examples where they will schedule an interview. If one of the spouses are under 18 or there's a large age gap like 10 years, then you can expect an interview. If the petitioner previously filed a spousal petition for someone else, expect an interview. If there is a past I-130 that was denied, withdrawn, or revoked, expect an interview. If the immigrant beneficiary is in removal proceedings, definitely expect an interview. If the application was submitted and there was little to no information attached to the application, expect an interview. Even if the relationship is real, you may now be called in for an interview if you fall within one of these flagged categories. Now, the interview may determine if your case is approved or denied, so you need to prepare for this like you're going to court. Bring all your documents, your original documents. Make sure that you know your application front and back, have photos with you, and that you're ready to explain your relationship in detail. If there are past denials or issues in your case, talk to a lawyer. We're here to help. 2. USCIS can deny without warning. So, before, requests for evidence or notice of intent to deny was a last chance provided by the USCIS to provide information that could enable them to approve the application. Well, now, if you fail to provide certain information or evidence, the USCIS can now have the discretion to deny your petition outright without giving you any notice or second chances through a request for evidence or notice of intent to deny. So applicants who submit incomplete or sloppy petitions or applications may be denied immediately, even if they do have a strong case, even if they do qualify. So submit all documents upfront, include proof of qualifying relationship, and make sure you include your certified translations, include the medical. Don't assume that the USCIS will ask for the missing information first. They could deny right away. 3. Filing a family petition does not mean protection from deportation. The USCIS has stressed that an approved I-130 or pending petition does not provide legal status. If the agency determines the beneficiary is removable, they may issue a notice to appear in immigration court and refer the case to immigration court, where you'd have to defend it, even if the petition is still pending. Now, you can be placed in removal proceedings while your petition is being reviewed if you have prior immigration violations, no legal status. So speak with an immigration attorney if you're here without your papers or if you have a previous removal order. Consider filing an I-485 if you're eligible, so this is where we can help to gain protection and avoid being placed in removal proceedings. 4. Changes in family status will be automatically converted, or it could even mean a denial. Now, when I say automatically converted, I mean if there are any major changes, like the petitioner becomes a U.S. citizen, they will automatically change the category to immediate relative if that applies. I do like this, but in reality, how fast will they be able to make this automatic conversion to a different immigrant category? No, it's still a good idea to notify the USCIS of any major changes you have in your case so that could speed up the conversion process. On the other hand, if a beneficiary turns 21, then watch out for an automatic change that could actually not make that person eligible anymore for a petition. So your petition could be moved into a longer wait list or canceled altogether. So before making any major life changes within your control, like marriage or divorce, talk to an immigration attorney. That's why we're here to help. Now, if you make sure you also are looking at whether you have to take action fast. Like if a child is going to turn 21, what actions can you take to avoid that? If your child is about to turn 21, for example, you can file before their birthday and check if they're eligible under the Child Status Protection Act. It's very important to make sure any changes that's happening, you consult an attorney. That's why we're here to help. 5. Filing the I-130 at a U.S. embassy is now limited to emergencies. Now, the USCIS has narrowed the conditions under which the U.S. citizens can file an I-130 at the U.S. embassies or consulates. Now, this is only allowed for military service members, U.S. government employees who are on a mission abroad, in emergency cases like medical or, where the child is about to age out. If you live abroad and you hope to file locally outside of the country to speed up your process, it's not going to happen if you don't fall into those categories. But you can still file through the normal USCIS channels that most people file through. So that doesn't affect that situation. Now, if you are going to file abroad, you have to fit within those categories. 6, multiple petitions for the same person may cause your case to be reopened for a fraud investigation. USCIS says that if you file more than one I-130 for the same person in the same category, it will be treated as a continuation of the first case and not a new case. But they will now reopen the record to check for fraud or eligibility issues if the first petition was withdrawn, returned, or flagged. Filing again doesn't erase past applications. Now, the USCIS may dig deeper actually if you had problems before. So be honest and consistent. If you had prior denials or revocation, then maybe an extra explanation is going to be very important here, and strong documentation to support the new petition. 7, withdrawing the petition is final even after a green card approval. So if your petitioner writes to withdraw and they haven't issued your green card, they can revoke the approval and that decision is final. So it's very important that you maintain communication with your petitioner. But if your petitioner is mistreating you, like your spouse is mistreating you or your parent is mistreating you, talk to an attorney. That's what we do. That's how we help. Talk to an attorney about looking at filing your own green card through VAWA. 8, stepchildren must be under 18 at the time of marriage, right? This is more of a reminder. It's not really a change, but a U.S. citizen or a legal permanent resident can only petition for a stepchild if the marriage was created before the child turned 18. If you were married and you married the parent after the child turned 18, then that child cannot be petitioned as a stepchild. So you will need to make sure that you evaluate eligibility and time your marriage carefully if you're including stepchildren in your immigration plan. Marriage before the stepchild turns 18 is essential for eligibility. 9, no legal status here. You're still removable during the process. Even if your I-130 is approved, you can still be placed in removal proceedings if you're not eligible to adjust status. So the USCIS confirmed that filing or having a petition does not give you protection from deportation. Undocumented spouses and children without adjustment options could be removed even while waiting for a green card. So don't assume that your petition protects benefits you. Make sure you're eligible for adjustment of status or visa before filing. If not, consider consular processing if possible. But this is where, guys, it's important to talk to us about your options to make sure it's a solid option. Now, no case is simple, not even marriage or family cases. Ensure you're getting the right legal help to successfully navigate this complex process. Stay informed, act early, and call us now to talk about your options to make sure you're doing it right. If this video was helpful to you, like, subscribe, share, and hit the notification bell. This is how we get this information out that can empower immigrants in this immigration journey. Drop a comment if you've been affected by the many policy changes that are happening right now. And if you're unsure where you stand, reach out for help. That's where the difference is going to be. We're here to help you. We're a safe space, and we want you to build a strong case that's going to push you through smoothly and successfully. Go to the link in the description of this video to book your appointment now. Until next time, take care.